You went to school. You went to school. I am tired of this. We are tired.
Eron Kiiza, a prominent lawyer who has been part of the team representing former presidential candidate Dr. Kizza Besigye and his co-accused Haji Obeid Lutale at the General Court-Martial, has started serving his sentence of 9 months in Kitale prison. This after Brigadier General Robert Freeman Mugabe, the chairman of the Army Court, ruled that the lawyer was guilty of the offense of contempt of court.
He immediately confronted the court orderly that was guiding him where to sit, but instead started assaulting the court orderly and banging the angle bars of the entrance, and is hereby sentenced to 9 months in prison to be served in Chitalia government prison.
However, Justice and Constitutional Affairs Minister Norbert, in an exclusive interview with NTV, said the court-martial should have given Eron Kiiza a lighter sentence.
I personally think 9 months is excessive. And Eron Kiiza is not the most notorious. There are other lawyers who have crossed the line.
If you look at the law, in particular Article 171 of the VPDF Act and other attending articles, the maximum sentence for contempt of court for proceedings before that court is 3 months. For actions that happen in the courtroom by an advocate is 3 months. But you have a sentence of 9 months. It appears to be unlawful.
Human rights lawyer Nicholas Opio argues that the court-martial authorities could have provoked lawyer Eron Kiiza to conduct himself the way he did, leading to his arrest and subsequent sentencing.
The atmosphere in the general court-martial cannot be said to be conducive for lawyers to practice before that court. Right from the point of entry to the premises of the court, up to the point of accessing the courtroom itself, to the conduct of members of the tribunal.
But how better could have Eron Kiiza reacted to the court orderly, even if he was provoked?
Eron Kiiza has been advocating for the non-prosecution of civilians in the court-martial. He has had exchanges with the tribunal before. Maybe yesterday was not a good time for him, and knowing what he was coming to do in court and looking at the way he was perhaps, in his view, of being obstructed from carrying out his duties as a legal representative of an accused person. He's a human being. He might have also got emotional and exchanged words with her. But as I told you, you are dealing with military men. And when you are in a military institution, really, discipline is the first thing that you must observe.
The military is not trained to argue, to apply logic. They are trained to apply force. So I wouldn't, if I was in his place, do the things that he did.
The legal minds are also concerned that Eron Kiiza was never given an opportunity to a fair trial, thus infringing on his fundamental right to a fair hearing.
For a fair trial, we expected him to have been to have had the charges read before, to have either have a representative of his or her being there, and then he takes plea. But we just heard that he had been sentenced, and for us, we think the tenants, the due process in terms of the right to a fair trial were not followed.
Minister Mao says now is the time for the judiciary to come out clearly on the sentence period for the offence of contempt of court.
I think in the light of what happened in the General Court-Martial regarding Kizza Eron, finally, the Constitutional Court and probably the Supreme Court will have to make a pronouncement so that sentences are not seen to be excessive. In any case, there should be a sense of proportionality.
Meanwhile, the Supreme Court has been challenged to pronounce itself on the petition filed over the Constitutional Court decision that ruled as unconstitutional the trial of civilians in the court-martial. Daniel Kibet, NTV.